This is one of those cases that just has some surprising details in terms of why it happened. This defendant didn't know this victim, and he's not arguing that he did commit the crime in terms of the killing, but he argues that it was not a murder, that it was something more like second-degree murder or manslaughter. Let's bring in our guest who is standing by, who can help us digest some of this. We have National Trial Attorney Mike Jaafar with us. Good to see you, Michael. What do you think about the choice to do a bench trial? Because if we're comparing this to the one in Connecticut where we're waiting on a jury and they're having trouble with someone who admitted to the killing but said that it was self-defense, here we have someone admitting to the killing but saying it was spontaneous, but they chose a bench trial.
You know, on trials that are not high-profile trials, many of the juries are waived, but you don't see it in high-profile trials, right? So my thoughts on the move to waive the jury, I agree with it, and I'll tell you why. I'm not in the trial, but you always know your customer when you're a defense attorney. You know when you're dealing with a judge who's seasoned, grizzled, and knows how to look at facts. In my opinion, I think this defense attorney knew that the community was not going to give his client any quarter, and that he was going to ask the jury to, if he had a jury, he was going to ask them to make a very big leap, which is, yes, he committed the act, but it was not murder. I think this defense attorney made the decision that, you know what, I need a grizzled veteran who's used and accustomed to looking at these facts, looking at these elements, looking at what potentially a jury instruction would be, and I can have this judge dice it down the middle and reduce the charges for my client so he doesn't get convicted of first-degree murder. I think that's the guess that this defense attorney did, and if in fact that's what he did, I would have done that. I've had many cases, Julia, where my clients were accused of some pretty egregious things, rape, first-degree rape, and then I waived the jury and I got an acquittal by the judge, or I got a reduction by a judge. I had a murder case where I had a judge reduce it because we waived the jury. We knew that the jury would not see it the way the judge would see it, whereas the judge would look at the actual facts. I've had clients where they were on camera taking a knife and stabbing somebody in the neck. We waived the jury. We got the result we wanted. So it happens all the time, more times than people think. And again, I think it's always because you believe that you got you need not a close call, but you need somebody to kind of dice the fact pattern in a way that a layperson, a civilian, just will not do.
Excellent analysis, Michael Jaafar, in helping us understand what likely went through this legal team's mind when making this decision. One thing that is clearly different when we see a bench trial is that defendant is there wearing his jail clothes, no jury to prejudice, and that's something we wouldn't see in a typical jury trial. Stand by, Michael. We're going